Sweden is okay. We have the sun out, so we are happy.
Oh,
People are shopping. Everyone is happy. It is holiday, so we have. I mean, in 1 week we shall be resuming school.
right.
So we have one more week, and then we are back to business.
Most of the time in Sweden, it is damn cold, isn't it? Much of the year.
Yes, but it is not so cold compared to Norway. We lived in Norway before, in northern Norway at the Arctic.
Oh,
We had 6 months of winter.
oh, oh, that's quite
It was so
harrowing.
dark, and sometimes it would even snow in the middle of June and July.
Oh,
Yeah, but
how
global
is it,
warming.
Dr. Marot? Oh, sorry. So,
Yes,
how is it down in South? Where are you right now? In Peru? Lima?
yes, I'm right. Yes, I arrived in Lima. Yes,
Oh,
the
a lot
weather
of
here.
family.
Yes, it's the weather is for them is right now. It's they have in the I'm in the coast in Lima, and it's for them is winter.
Oh,
Wow.
Yes, right now it's like it's 8 a.m. and it's like around 10 degrees. It's not too
Oh,
cold.
that's more or less what we have in Johannesburg. We are encroaching winter. It's deep in winter. I don't like
Yes,
it. Usually,
the
I
pro.
disappear to New York, as I told you. By now, I'd
Yes,
be in New York, Coney Island, for my summer. But
hmm.
COVID has done his part.
yes, in the winter. But here, I mean, it's not too cold. In the highlands, it's colder.
All right.
Over 2,000 feet sea level.
Yes.
Uh, they are in summer. In the day, you can reach 35 or 30 degrees. It's dry weather. It's nice.
Mhm.
Nonetheless, around 6 p.m., it goes down below zero. So you
Oh.
need to, yeah.
All right.
Wow.
Uh,
We could start off. It is already 4 past 3. We're down in Johannesburg. Um, I wish to welcome our viewers wherever you are, millions of our viewers world over in the United States of America, Canada, South America, Europe, Africa, Asia, India, Japan, Australia. Welcome to this session. This is yet another session where we address pertinent issues that confront the fraternity within the international criminal justice. The topic for today is immunity from jurisdiction of the International Criminal Court. And we have a panel of specialists, experts who are ready to be able to expound on key principles revolving around that particular vexing question. It's not a new question entirely. It has been repeatedly featured over the years, and it has generated quite controversy in terms of resolving what the interpretation or the proper construction of the statutes are. The Rome Statute today, I believe, will focus largely, my colleagues, the experts, my friends, dear distinguished professors, dear trial attorneys, dear distinguished emeritus professors, whom you'll see shortly, they are going to focus on these points. And I believe their discourse will revolve basically around two key articles of the Rome Statute. The first one being Article 27 of the Rome Statute, which effectively, as if positively read and construed, would mean that actually the immunity of head of state or government or officer or in any government is of no effect, is immaterial as far as the provisions of the Rome Statute are concerned. In other words, the courts, the International Criminal Court, would not take into account any plea that seeks to make somebody escape criminal responsibility based on the issue of immunity of any kind, whether at national level or international level. I believe my colleagues will be looking at that section, that article in juxtaposition with another article that has been largely relied upon by a number of individuals who try to escape criminal responsibility. And that is Article 98 of the statute. Apart from 27, we have 98, and I believe they will delve into details. It's not my duty right now to preempt anything, but that particular Article 98 of the Rome Statute deals with cooperation. In a way, it says that the court may allow instances where if the cooperation of a third party may interfere with the obligations of that third state in respect of the obligations or interests that are carried out in international law. So tonight we're going to see a very, very well-charged discourse. We know that there have been presidents like the former head of state al-Bashir, who have tried to escape being brought before the court by arguing on those particular sections, particularly 98 and other arguments. We have seen cases where in Malawi, the Malawi case, for instance, where the state argued that they could not be able to proceed with the arrest of al-Bashir. They could not cooperate or surrender on the basis, the accused person, on the basis of protection that conferred upon them by the International Criminal Court Rome Statute under Article 8. We have seen South Africa case argued as well. All these are going to be unveiled today. And we thank you very much for your time. And above all, I want to thank my colleagues and friends, dear colleagues, those in the fraternity who have taken their time all over the world. Like we have Council Brenda. It's nice to have you always, Council Brenda. And you wave the viewers. Yes, so you're expecting great things from her. And my co-host, I'm the host, but we have a co-host who does a greater job than myself, and that's none other than specialist attorney Dr. Giavoni Marotta, who has handled matters of child and all issues related to international law. So, Dr. Marotta, you may wave our viewers.
Thank you. Hi, all. How you doing? You're welcome today.
I'm handing you over to Dr. Marotta. Thank you very much.
Thank you, Professor Milton. Hi, everyone. Today we are going to have a discussion related to the immunity and its relation with the jurisdiction of the International Criminal Court. As Professor told us before, there are some cases right now in the ICC where the prosecuted international criminals are trying to challenge under Article 98 the jurisdiction of the court in relation of their immunity. Today we are going to have as panelists of this discussion once again Professor Alessandro Lanciotti from Italy, also Maria Mercedes Pisani. Both they are international professors. Also, they were part of the Rome Conference delegate for the ICC. Also, we are having Manrit Kaur. She's an international criminal attorney. She for the ICC. Also, we have Brenda. She is an special attorney at law. She's from Sweden. Right now, she's driving. Also, we are going to have the companion of a special expert trial attorney Arthur Tralli. He was an attorney back in the 90s for the ICTY. Then we're going to have from India Professor Darwan Kanarshipati from the. He has an experience of 30 years in international law. Also, we are going to have the International Legal Counsel. Also, he is a visiting professional for the ICC, Tony Raymond Kiravira. Also, we have the companion of Deborah Wow. She's a senior state counsel, also visiting the ICC. We're going to have the director of the SA Government Legal Service from South Africa, Government Legal Services, Ditaba Rantsane. Also, we have the companion of Professor Emeritus Kawame Frimpang, and we are going to have the companion of the from the Government International Relations Departments of Justice from South Africa, Malesala Leso. And finally, we have also the companion of the legal scholar Gobile Magwasa. So, hi everyone. We're going to start today with, as Professor Milton made the introduction before me, um, uh, what is going on right now in some trials, and also the coming trials related to the immunity from the jurisdiction of the International Criminal Court. Thank you, everyone who wants to participate, as always. To start um, this discussion is very, very welcome.
Thank you, Dr. Marotta. It appears among our panelists, some are still to get on board, but we have Brenda, Council Brenda, and Emeritus Professor Frimpong is online, but I can see he's unmuted. The video is not on. Hello, Emeritus Frimpong. Can you hear us? Okay. We seem to be having Professor Dr. Tripathi is just coming online. I've just ushered him in. Yes, Professor Emeritus Professor Frimpong, can you hear us?
Yes.
Oh, yeah, we are. We have the professor with us. Welcome, Professor, to this session. We have Dr. Marotta has just ushered. Can you greet the viewers, Professor?
Excuse me.
Can you greet the viewers, Professor Frimpong? We have millions of viewers all over the world. You can say hi to them.
Please, greeting from Atlanta, USA. You hear me?
It's cutting. It's cutting. It's cutting. Can you hear us? Can you hear us?
Yes, I can hear you.
Okay.
Can you hear me?
Okay, proceed, Emeritus. We can hear you.
Okay, I was saying greetings from Atlanta, USA.
Awesome, awesome. Nice to see you one more time, Emeritus. We also have Professor Dr. Dwarakanath Sripathi, as usual, is with us. Professor Sripathi, how are you? Can you greet the viewers?
Yes, of course I can.
Go ahead.
I'm a little indisposed because I had a stomach upset last night. So feeling a bit weak, that's all.
Nice to see you, Professor, as always.
Yeah, same here too.
I've just given an introductory remark on the issue of the immunity and handed over to Dr. Marotta, who had requested that whoever is ready may now proceed with the presentation. It's open to the panelists. And viewers, as I indicated before, we have panelists of experts, people with outstanding performance who have done great things within the fraternity of the legal profession and academia. All right. So we hand you over back to Dr. Marotta to coordinate the presentations.
Okay, thank you, Professor Milton. Yes, the point of today is the discussion in the relation between the immunities from jurisdiction related to the ICC. So the question here is how the court. So what, for example, al-Bashir, he's challenging the court under Article 98 of the Rome Statute. So the question here is at which point the immunity from the ICC should work in the means of, for example, a diplomatic and consular immunities. I bring this on the desk. For example, Article 41 of the 1963 Vienna Convention. How is the relation between the Vienna Convention, the Article 41, with the articles of, of the Rome Statute in related to immunities? Who wants to start? Professor Shipati? Always,
As
yeah.
usual.
Yes.
As usual, that's why I'm laughing. Yeah, 30 years are not for nothing.
Yes, that's true.
Yeah, yes.
Hello to all the panelists and the viewers. Now, today, the topic of the international discourse is immunity, state immunity, and the International Criminal Court. As mentioned by Dr. Marotta, he referred to the Vienna Convention on Diplomatic Relations, 1961, and also the Vienna Convention on Consular Relations, 1963. Now, these are the two conventions that have been signed by the states and which provide immunity to all the diplomatic officials who are representing their states on the territories of other states. Uh, there are a few theories which speak of why this immunity must be given to the diplomats. So one theory which is very important is the functional theory. This theory lays down that since the diplomatic representatives of a state functioning on the territories of other states have to perform their functions, and if these immunities are not granted to them, then they may not be able to perform their functions efficiently and smoothly, because there could be an interference by the government of the state where they are functioning. And frequent interventions by the government may not really help the cause of the diplomatic representatives. And they also are empowered to perform certain special functions. And because of these special functions, it's necessary that the diplomatic immunities must be granted to them. There is a long list of diplomatic immunities that have been granted to these officials. The first is inviolability of the person. Now, what is meant by inviolability of the person? It means the body of the diplomat cannot be injured. That is, no physical violence can be directed against the diplomatic body, the body of the diplomatic person. And any injury that may be caused to the diplomat is considered to be an insult to the sovereign whom he represents. So he cannot be touched. Then another immunity is immunity from civil jurisdiction of the courts in the country where he is functioning. When we speak of civil jurisdiction, the diplomatic envoy may enter into contracts, and he could be involved in other cases which are of a civil nature. And suppose something happens and then the other party goes to the court of law, the diplomatic representative can always say that he is immune. He is not supposed to appear before the court of law because he has immunity. And there are exceptions to this. A diplomat cannot always claim immunity under the Vienna Convention. There are certain exceptions. We will not go into them. Then the next one, the most important one as far as the discourse is concerned, is immunity from criminal jurisdiction of the courts where the diplomat is functioning. So any crime that is committed by a diplomatic envoy, that is an ambassador or a high commissioner or a legate, they cannot be criminally prosecuted by the local courts of law of that country. They can again always say that I am a diplomat, I have immunity, I do not want to appear before the court of law. I cannot be prosecuted. He can say that. So this is how the immunity has been granted to diplomats. But there is a conflict today between two issues. One is the protection of human rights all over the world. And there are so many international instruments that have been signed by the states for the protection of human rights. And these instruments also include protection of the rights of citizens at the hands of the heads of states. Then the other issue is the the state immunity that is granted to heads of states. Now, of course, this state immunity is granted to heads of states under well-established law. And now, generally, when the head of a state is any crime, it is the obligation of that state to prosecute him. But the state immunity also clearly says that as long as the head of the state is occupying his office, he cannot be prosecuted. Probably after he leaves the office, can be prosecuted. So, in many states, because of the state immunity that has been granted by the well-established law, not only the national law but also international law, heads of states, crimes with impunity, they clearly know that they will not be prosecuted. Now, the other question is whether the states at the time of the signing of the Rome Statute have the representatives, have they agreed to forego this state immunity that has been granted to the heads of states? What were the discussions? What was the outcome of such discussions? If the states have not agreed to that, then probably the ICC cannot proceed. No doubt, the ICC claims universal jurisdiction, and there is also an argument on the part of the ICC that it only proceeds against individuals and not states. But the question is, when we say that the ICC has universal jurisdiction, but till today, the ICC, I feel, has not been very successful in exercising this universal jurisdiction, because we can take the example of Omar al-Bashir. Now, just taking into consideration the Sudan state itself, then all the other African countries who have openly invited al-Bashir to come to the states, clearly in violation of the provisions of the Rome Statute, because we are aware of the fact that a state, when it finds any fugitive on its territory, then there is an obligation on the part of the state to surrender him to the ICC. But al-Bashir has been freely roaming in the African continent to all the states, and where he has been given total freedom to move around without any country trying to impose any kind of restrictions upon his movement. So this is where I strongly feel that the states at the time of the signing of the Rome Statute probably have not considered this particular aspect, and they did not even realize at that point of time that this aspect could create so many problems in the future. That is now. So once again, I strongly feel that uh, one important principle which speaks of sovereign equality of states. Now, these heads of states have been granted state immunity because the states feel that their officials should not be subjects of any crime of criminal jurisdiction under the laws of other states. That freedom should be maintained by the uh, states. So that is why we have this principle of sovereign equality of states, and Article 2, Clause 1 of the United Nations Charter speaks of this sovereign equality of states. That is, all states are equal without, irrespective of their size, their population, their financial position, their territory. Every country is considered equal if they are members of the United Nations organization. So a state which has a very small territory, like there are so many states in the world, like the state of Nauru and then Micronesia, they're all very small countries when compared to big countries like the US and Russia. Because of their status as a member of the United Nations organization, they are considered equal to the US and other big countries. So it is because of this sovereign equality of states, the state immunity has been granted to the heads of states. And the heads of states should also have a kind of uh, morality, ethics. That is very important. Just because they have become the head of a state and just because they have power in their hands, they cannot act, what you say, in a very indiscreet manner. They cannot become autocrats. They cannot become tyrants, dictators. That moral sense of feeling every head of the state must uh, have. So only when they feel they are morally and ethically responsible to the people, they can realize that they are heading the country to do some good for the people and not to violate their rights and not to commit crimes against the subjects. Whatever the conflict within the state, whatever the issues, however serious the issues may be, but this sense of morality and ethics, every head of state must have. If the heads of states can, maintain this, then the ICC may not have so many problems. In the sense, there won't be crimes committed, and the ICC also may not proceed against the heads of states for whatever crimes they commit. So the question before us is whether the state immunity that has been granted to heads of states is a permanent immunity or not. And if it is permanent, for how long will it be? Because when a head of state completes his office and then comes down from his office, steps down from his office, then there is a possibility of the state prosecuting him. Now, it is common knowledge that when a person commits a crime on the territory of another state, and that state gets the right to prosecute the person. And that is a well-established rule of international law. But the problem is when a person, particularly the head of a state, commits serious crimes as the head of the state within his country, can he be subjected to jurisdiction of other states, or for that matter, even the ICC? That is the big question before us. So how do we? That is my question to the panelists. Thank you.
Thank you, Professor Dr. Sripathi, for that erudite presentation as usual. We were laughing when you were picked up because you have been a consistent target of past presentation by Dr. Marotta. But as we said,
Thank you, Professor Sripathi, for your presentation.
can we check
Yes,
Marotta?
it was.
Check out Dr. Marotta?
Yes, I'm having some trouble with.
Yes. We want to
Yes,
clear.
yes, there's like
Somebody having
static. Do you hear me?
there is something in the background. Can somebody check if they have YouTube on the background? They could have it, or a TV. Okay.
No, it's like I don't hear a background. I hear like some statica.
Before you proceed, can I have this occasion to introduce Dr. Ransane and Dr. Ditaba? It's nice to see you after a while.
After one week, Prof. How are you?
All right. Say hi to the viewers all over the world.
Greetings to you, colleagues and viewers all over the world. Fortunately, I managed to join today, even though I can hear that the sound. There's quite an irritating sound, but greetings to you all.
Okay, thank you very much. Dr. Ditaba Ransane is a very senior director in the government of the Republic of South Africa. And today's discussion also involves partly what South Africa did in connection with community issues. So I think it will be of interest. We had Mr. Malesela last week, who is also director in the international relations. So you can see the Republic of South Africa is extremely interested in these matters. It's always a leader, actually, the world is part of the world. So it's a pleasure to have you, Dr. Ransane, in the panel. Thank you very much. I hand you back. Yes, Dr. Marotta, over to you.
Yes, okay, thank you. Welcome, Professor Ditaba. Okay, as Professor Sripathi explained, related to about immunity, I have another question here. It's possible for
Sorry, Dr. Marota,
Yes.
are you okay?
Yes, I'm here. Yeah, I don't know. Maybe someone is hacking us. I don't know because there was like a strange sound, and then there's like an static. Yeah, what I was telling here is, for example, in the United States, the U.S. Department, I have the information here. They have regulated a little bit the the um, the Article 41 of the 1963 Vienna Convention on consular relations. They have a directive that, for example, if there is a grave crime, there is no immunity at all. So, for example, the Department of State to mean a felony. For example, there's a case in U.S. versus Cold where they sharp this information. For example, they say that here is I'm going to read a little brief of the case, holding that Yugoslavian consul general was not entitled to consular immunity from money laundering charge because money laundering constitutes a grave offense. So maybe and that's the question I give to all here. Maybe if the countries around the world they can um, challenge a little bit the meaning of the immunity related to grave felonies. Um, I see grave felonies, for example, crimes against humanity. Probably, if they in their national laws can change that, it will aid a little bit the prosecution of international criminals in the ICC. That's my question. Who wants to? Okay, Brenda.
Yes.
Mhm.
Okay. Thank you so much to all the viewers and my colleagues. Well, I take this opportunity before the whole team comes in, and I just wanted to react or to add on what Professor Spati said in the very beginning concerning the immunity. In this case, in my view, uh, immunity in this to the head of state should be looked at in two parts. I think we should take off if we use the legal terms and the legal tools more deeper, then we might not get there, because that is probably where I feel like the international court has unsuccessfully managed to contain this bit, because it looks like it's an issue of political issues, which is so much rooted into the leadership of each state. And when you look at the ICC and the complaints of the people on the ground, literally it is like a fight between the ICC, a fight between the powers behind the ICC and the powerless ones down, and that brings a lot of hiccup between the country, between the laws that are already put down that we should be using profitably for everyone, because ICC looked at broadly should be having international jurisdiction over every country, but it is looked at in that way, and yet they do not seem to be acting in that way. And most of the countries look at it like it's just a tool against African countries, and that is why I think it is a bit political and there's power in there. So when looking into these issues, maybe we should have different hats put on our heads and keep changing them in order. And probably to strengthen the ICC, maybe they should look into it and see how to amend or to give power to the ICC to do their work freely. Because I know most of the countries will look at America, they will look at Russia, they will look at everything, and they'll say, why are we being the target? So in my view, it is the different type of hats that we need to put on, and politics is taking over too much instead of the law taking over. And then of course there's the issue of human rights, because the same person being given immunity is the same person still abusing the citizens of the same state. So all these looked into, it makes the whole issue a bit of a complex that calls for a look into the deeper statute and see what to do. That's my feeling. Thank you.
Okay, thank you, Brenda. Thank you for your great intervention. Okay, anyone else who wants to add what Brenda has said to us?
Dr. Marota?
Yes, do you hear me?
Permission, possibly, I think for the benefit of our viewers, those who are lay persons and also those who are lawyers but not well schooled in matters of the international criminal law, I think as a precursor, as a preamble, I should be able to highlight what I feel are the basis of this discourse from the Rome Statute. This will take about minutes or so. We have within the Rome Statute, the essence of immunity is revolves basically upon around the provisions of Section 27 of the Rome Statute. For those who are not aware, Section 27 of the Rome Statute provides that it is actually deals with irrelevancy of the official capacity. It is immaterial what position you hold in any situation as far as this particular article is concerned. It provides that the statute shall apply equally to all persons without any distinction based on official capacity. That's the first provision. So the application of the Rome Statute shall proceed regardless of whether you are a head of state or whether, but the second provision, the second part of that article, sub-article 1, makes it even clearer. It says, in particular, official capacity as head of state or government, a member of government, or a government official shall in no case exempt a person from criminal responsibility under this statute, nor shall it in and of itself constitute a ground of reduction of the sentence. So we can see here within that sentence, there's something that is very critical from the drafting perspective. The use of the term shall is used in this context in a mandatory form as contradistinction to may, which is discretionary. So by the drafters putting in the word shall, they're indicating that's mandatory, that this provision shall apply regardless, immaterial. It will be material that one is a head of state or whether they are holding position in government or any other official capacity. Actually, this particular article deals with capacity. So it is the essence of any argument that has been advanced to support the position that the statute does not afford immunity. It does not afford protection, where immunity in this case means protection from criminal responsibility or exemption, where otherwise that individual or that officer would be liable by virtue of being criminally responsible for acts they've carried out in their purported immunity state. They would still be held liable. So the court would not look at whether or not that person has immunity, not only at international level, but as we shall see, even if that immunity is recognized at the domestic municipal level, the ICC shall not take cognizance of that. It shall not recognize that kind of immunity. So that is very critical as the argument will proceed. I believe our panelists will be addressing all those issues. Then the second limb of this provision, Article 27, sub-article 2, immunities or any special procedure rules which may attach to the official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over such person. This is what I just indicated. I just explained a few minutes that. So whether that particular individual enjoys certain class of immunity, whether there is a particular category of immunity that's accorded that particular person at the national level, that particular grant of immunity shall not bar the ICC from exercising its discretion or its powers in connection with pursuing criminal responsibility under that act. Then there appears to be a contradistinction between that particular article and another article which the other arguments have been pursuing and resting upon to attempt to escape liability. And that's Article 98 of the Rome Statute. For the sake of our views, I'll set out very quickly. Article 98 of the Rome Statute states that cooperation with respect to waiver of immunity and consent to surrender, that is actually what it provides. The court may, mark the word may there, the court may not proceed with a request for surrender or assistance, which would require the requested state to act inconsistently with its obligations under the international law with respect to the state or diplomatic immunity of that person or property of the third state, unless the court can just obtain the cooperation of that third state for the waiver of that immunity. This is what Professor Dr. Sripathi had dealt with when he was talking about immunities and inviolability of certain persons. So you can see that this article provides a certain exception, but it is debatable. It attracts great intellectual discourse as to whether that exception wholly applies in connection with Article 27, which was couched in very, very mandatory terms. That's part of our discourse, as we shall see. Sub-Article 2 of 98 provides that the court may not proceed with a request for surrender, which would require the requested state to act inconsistently with these obligations under international agreements, pursuant to which the consent of the sending state is required to surrender a person that state to the court, unless the court can first obtain cooperation of the sending state for giving of consent of the surrender. So these two articles, Article 21(7) on the one side, on the other hand, we have Article 98, have in a way provided sufficient breeding ground for discourse, controversy as to the parties depending on what they are seeking from the court. So really, that's for the sake of our viewers. Those are key areas. Of course, we also have other sections, 89 and all that, which our experts we have here will be able to delve into. So thank you very much, Dr. Marota. I just wanted to indicate that those are provisions. And before I conclude, it is critical to note as we discuss further, as we have the discourse, that really to be able to have an exception to that immunity would almost render the statute inoperable. It would be self-defeatist. That's my humble view. I'm not drawing any conclusion, but I'm instigating and provoking thought. Thank you very much, Dr. Marota, and I hand it back to you. You may proceed with the hosting. Thank you.
Yes, thank you. With your intervention, you remind me the case of Carles Puigdemont. He's from Catalonia, from Barcelona, Spain. Last year, I think, he was in charge of all these riots for separation of Catalonia from Spain. Nonetheless, his group was found under criminal investigations. They have committed some fraud crimes and money laundering crimes. And why the reason why I bring the case of Carles Puigdemont over the desk, because at that moment when these felonies were committed by him and by his group, he was part of the European Parliament. And according to the European Parliament, you need to have a hearing before the European Parliament so they can reject your immunity so you can be trial. It's a very short process. It's like happens, I think, in all the parliaments around the world. So, he was the Spanish prosecutor for I don't know if it was because of the problems that was going on in Spain, and he continues the investigation, the prosecution, also the judges try him, and he was found guilty. Nonetheless, he went to the European Court of Human Rights. He presented his case, and the court said that even though the procedure was not according with the European standards and all the conventions that Spain has signed related to this issue, and they decided that the trial was null and void because the Spanish government did not activate, I don't remember right now which article of the European Convention related to the immunity of the when one of their members have committed as I spoke, they have of the a very hard felony. So that's the I think what the Article 27 tries to do is to in this kind of cases when there is, I mean, money laundering is not considered right now an international crime, but all the international crimes that are in the Rome Statute are considered. They try to avoid this right that the person has that is going to be banished from his immunity in international level or national levels, because they want to brought to justice. But I'm challenging this question. What about due process rights? I mean, since we I think I mentioned this. I don't know if it was last session or the session before last session about the Feindstrafrecht, the enemy criminal law that says that that was made by Professor Gunther Jacobs. He said that according to the new crimes and the new evolution of crimes, the due process rights are going to be reduced, so we can make accountable those who had in the past made this kind of atrocities. Nonetheless, in some point, in his work, Professor Jacobs, he tells us that this can also work against us as a society in some point by police states. So the immunity related to Article 27, from my point of view, from a point of view, it's like, it's a very thin line between we want to do things correct so we can trial someone who has made this atrocity or these horrible crimes. But the question here is, we can do that violating, in this case, his right to have a pre-trial related how to ban his immunity. I mean, I bring to the desk this question, because in some point, okay, he's a horrible criminal, but the world changed, the country changed. Then I don't know. It appears like the book 1984, a state police. So how we as society can defend of that? Because here, I think, I mean, if you mislead in some point or you surrender, not to be so strict with the due process, so you can trial or prosecute the bad guys. This in the future, this can play against you. So that is my question over here. Does the Article 27 should stay that way, or for us? That's why I brought the case of Carles Puigdemont, because Carles Puigdemont was using money from he was using money from the government to use his campaign against the Spanish government. So that's a felony according to the criminal statute in Spain. So that's my question here. Should we follow these enemy criminal law policies that are in the Rome Statute, for example, in Article 27, or there should be, like a pre-trial in the country or done by the ICC? I don't know. I mean, that's so we can take off the guy with his immunity and can be prosecutor in the ICC. Anyone who wants to answer that question is very welcome. Because since I was a law student, I always have in my mind, because I think that there should be, I mean, some kind of process, even though he's I don't know, he's even the Hitler was captured alive, and I don't know, he made some kind of atrocities, and we go back to that moment, and with all the international legislation that we have right now. I mean, even though he was the president of, I don't know, this Germany in this future I bring here, and he was found guilty of doing wrong against these horror crimes against some group of their nationals. I think even though he has immunity, he was going to be tried. I mean, there should be like a pre-trial process before, so we can get it. Okay, we do everything by the book, so now we trial you. But I don't know. What do you think? We need Article 27 to enter, like, you know, like a bulldozer. Okay, I don't care if you have immunity or not. We are going to trial you. But what do you think about the due process in this case? Because according to I don't know, to the International Convention, also in countries where their parliament. Okay. Yes.
I just got some I'm not sure that Professor Emeritus Professor would want to say something, because he might be leaving us soon.
Okay. Yes.
Yeah. So I just, maybe you can just find out from him. Okay.
Well, I think American, as usual, is trying to bulldoze this way, so I have no choice.
Okay.
Well, I would like us to first and foremost address the issue you raised in relation to Professor Party's earlier contribution, brilliant ones as usual. And if you look at Article 27 in relation to 98, as we were trying to explain, there is that substantive position taken by the international community and Article 27. So strictly speaking, from my point of view, 98 must be read as immaterial depending upon the strict interpretation. Because if you are going to recognize that a state may abdicate its responsibility by not surrendering mainly because of immunity, then you are contradicting the very provision of 27. 27 is saying that whether you have immunity or not is immaterial. So on what basis are you going to allow a state to hide behind immunity for not surrendering?
Emeritus Prof, can you just check on your audio a little bit? It appears it's coming in staccato. I'm not sure what could be, but I believe that kind of
is it okay now?
It's not so much, not well yet. Can you? Okay, can I let me mute you and unmute you, adjust and see whether there'll be any difference, so that we don't use out of the phone.
Microphone. I was using my earphones. Is it better now?
Not on my side.
I don't know. Man.
Let me try to mute. A second, you retune and then come back. Okay, can you try coming back on air, please?
Is it better now?
It's still having a problem.
Oh wow! Then what could be?
Video and upload
Okay, can you come on air again?
Yes, I'm on there. Can you hear me?
Yeah, we can hear you, but vibrating. very violently.
Really?
Yeah.
Then
But
let me turn
give me about 5 minutes to sort out, if possible. We see whether we
okay. All right, sure.
allow
Okay.
for.
All right.
Hand you back over to. Okay, let me readmit you again to see whether there'll be any. Okay, can you try, Prof?
Uh-huh.
Yes. Can you come? It looks much. It sounds better.
Okay, then let me turn off the other phone. I think maybe
Yeah.
it was because the other phone might have been there. Okay, let me turn that one off.
Yeah, the other phone was a problem.
Okay.
This is much better. Okay, Emeritus Professor, when you're set, you can proceed.
All right. Okay. Oh boy. The other phone is still on. Turn it off.
We can hear you. Can you proceed? Make a test.
Okay.
Yes.
I'm
Then
trying to.
switch off the other device so that you don't
Yeah, I'm trying to turn off the other device that is refusing. Okay. Hello.
Hello?
Is it better now?
Much better, much better. Okay, Emeritus, you may proceed.
Okay. No, so the point I was making, sorry about that difficulty. The point I was making is that if you look at the provisions under 27, as you pointed out earlier, they are couched in such a way that it is mandatory on all states and international community to ensure that immunity doesn't apply. But if you read that in relation to 98, what 98 is suggesting is that a state may rely on immunity for not surrendering a person who is requested by the international community. That obviously is inconsistent with 27 says that immunity doesn't apply. So any serious court, by adopting strict interpretation in terms of the objectivity behind the provisions, will be able to say that, no, you are rather under obligation to surrender. So I think the drafters of the statutes should have actually in NTA say, provided that even if a person is seeking protection under, oh boy, a person is seeking protection under, excuse me, under 98, that shall not have any validity by virtue of 27. That's how we should read it. So at the end of the day, maybe at some point in time with the support of Professor Shipati and the experts, when we have to revise the statutes, these must be taken into account in terms of making the provisions more appropriate so that there be no room for any immunity. And particularly, Professor Marota, the due process should not be an issue at all when we are dealing with a criminal. You know, in matters of immunity, I don't think we should tolerate that at all. Thank you. Bye. I hope I'm not confusing you.
No, that is very interesting, the intervention, Emeritus, very interesting. Indeed, there have been a lot of questions put across that if the drafters, if the intention of the drafters as encapsulated in Article 27 and as couched in that language of shall, as we know, the interpretation meaning mandatory, then what is the position of Article 98? But then we'll also see in retrospect, Dr. Marotta talked about the Vienna Convention or Treaty, the interpretation aspects. We'd have to look at the interpretation. There's the doctrine of effectiveness, of the instrument. So we'd want to question ourselves, what was the purpose of 98? What was in the hands of, in the mind of the drafters? So we have to go back. Well, we have notes, we have footnotes that we check in the drafting history. When we get to the drafting history of the committees that drafted this particular, but you'd see that the intention was that any event to attempt to grant immunity wholesale would actually render the whole, statute inoperable. As you look at the other jurisprudence that came in, like the arrest case, we have the arrest warrant case, of before the ICJ of 2000, where the ICJ made a ruling. The jurisprudence in that court actually holds in consonance with the fact that it was the intention not to have that immunity in place. We have other cases like the Malawi case, the South African case. All these, when we examine this jurisprudence, really the issues that the Americans and come to fall. But the point is, what was the essence of the drafting of the 27? And you could see that article, there's a connection between Article 27, Sub-Article 2. There is a juxtaposition relationship with Article 98. It appears at the time 98 was being drafted, there was something in mind with Sub-Article 2 of 27. I leave that to the experts to expound further. Thank you very much, Emeritus, for that presentation, and I'll hand you back to Dr. Marotta to coordinate the other presentation. Thank you.
Thank you, Professor Emeritus Frimpong, for your great intervention and to clarifying some points related to the issue. Okay, who wants also to add?
May I add?
Yes, come on.
Thank you, Doc. Dr. Marotta is talking about due process. Should we maybe ignore due process or what? And at the same time, we are trying to enforce the rights of others. And by ignoring due process, we'll be trembling on the rights of the very same people that we are trying to bring before the court. And that might also affect the integrity of the institution itself. And now, one of the most interesting questions is, what is the purpose of Article 98? From a different perspective, I would say it enforces due process. This is how I think it does. Because remember, Article 27 does not give you an opportunity to challenge. It says immunity is not granted, period. But now, on the same breath, we have an argument that each case must be considered in its own merits. Now, what if my merits would warrant that surrender should not be granted? Now, Article 98 says it may not. It opens a door for an argument to say, why do you think we should not enforce Article 27 against you? In terms of Article 98, you are given an opportunity to advance an argument why it should not be surrendered. Why should the obligation of the state not be overlooked over the responsibility, the international towards the ICC? So in my view, 98 is there to say, let's see if there are any circumstances that warrants otherwise. Now, Brenda and Prof. Sripaki spoke about politics, and I think this is one of the first things I made when I joined the panel, to say the success of the ICC depends entirely on the political will of each state to cooperate. And when you listen to that, or to that argument, you realize, based on the following, there might be there might be very good instruments, international instruments, that are there in place to make sure to ensure compliance. But how effective are they? Do we have some punitive measures that can be imposed against states that are not complying? If we don't have that, it means they will be able to ignore their responsibility with impunity. Now, the political will is very critical. How do we ignore the responsibility we have as a state towards other state, or a foreign, the head of another state, to grant immunity? I mean, we know that ordinarily heads of state will have immunity from prosecution when it comes to any offense that are committed in another foreign country. Those who are there operating with the responsibility to discharge some functions on behalf of their states in another foreign country, also they might have immunity. Now, when we go to an international level, how do we ignore that responsibility? Remember, most of these states become members to the Rome Statute through by being signatories. The moment you sign, we look at what are your responsibilities nationally? What instruments do you have to ensure that you honor your responsibilities? And now, after signing, when you sign, become a signatory, it means you accept that whatever instruments I have domestically will be superseded by the Rome Statute or any other statute of an international level, for that matter. So it should not be a problem for you to comply with the obligations of the Rome Statute, because you sign knowing that you might be required to ignore or your responsibilities in terms of respecting immunity that head of states have. So by signing, you are actually accepting that this legislation supersedes this domestic legislations. However, as I said, 98 is there to allow the state to argue and say, I cannot surrender because of 1, 2, 3, and let the court decide that, under their circumstances, we do believe that you are justified not to comply or not to surrender a specific person. So 98 is there to just strengthen due process. That's my argument. Thank you. Thank you.
Thank you. Thank you, Professor Atzane, for your intervention. Anyone else from the panelists who wants to add something with what Professor? Yes, Professor Chipatri.
The political will which Dr. Ansani was talking about is very crucial for the success of the ICC. Article 27 is mandatory that the court does not recognize any immunity that has been granted to heads of state by their own governments, and it shall proceed. And Article 98 somewhat dilutes Article 27. But despite this clash between Article 27 and Article 98 of the statute, what is important is the obligations of the state towards the ICC. Because a state, when it signs a treaty or a convention or an agreement or a protocol, there is one important uh, principle under international law, which is a Latin expression, in fact, pacta sunt servanda. That is, obligations must be kept in good faith. This is very important when any country signs a treaty. So also in the case of the ICC statute that the countries have signed, and they were aware of Article 27 and Article 98. So whenever a situation arises in a country, then they should not go back on their obligations. Since they have signed the statute, they must follow the statute. But however, this is not the case in various countries where crimes are being committed by the heads of states. And some countries feel that the court is being partial. However, they are trying to keep away from the fact that crimes have been committed. Crimes have been committed. And that is something that the states cannot deny or refuse. And to say that the court is partial is totally wrong. Because these states are very much aware of Article 27. So it becomes a duty and a strong obligation on the part of the states to go by the provisions of the statute, that is, to go by the rule of law. But however, this political will that is exercised by the states is a kind of an impediment in the functioning of the court. So states must overcome this impediment and try to be more reasonable in their thinking. The thought process of the states, the leaders who head the states, must change. Only when this change comes, we can expect a better administration of criminal justice in the world. So this is mine. Thank you.
Thank you, Professor Shipatri, for addressing those important thoughts related to what Professor Ditaba has also shared with us.
I3 10th generation, model 1008. Box మీద నా పేరు.
Okay, I've unmuted him. Probably that was.
Yes, I didn't know it was part. Yes, I wanted to was part of the desk session or was something else. Yeah.
Okay, Dr. Marota, you can proceed.
Okay. Well, yes. As also this. I have something here. One place. Okay. Also, we have also in the before the ICC, we have some also want to bring to the desk the case of concerning an arrest warrant that happened 20 years ago. It was between the Congo and Belgium.
Yeah.
The case concerning the arrest warrant. I mean, it happens. Yeah, it's going to be 20 years ago.
20 years.
Yes, exactly.
1,000. Yeah, you're right.
Mm-hmm. So it was related to against the Minister of Foreign Affairs it was in office. I mean, the Minister of the Republic of Congo, Mr. Abdoulaye Yerodia. And Belgium decided to, um, and they challenged what we were discussing previously, that accordingly to the immunities enjoyed under international law by the Ministry of Foreign Affairs, according to Belgium, did not represent a bar to criminal prosecution in certain circumstances. I think the case of Belgium versus Mr. Abdoulaye was, I think it was it triggered Article 27 in some point. I mean, I think it was in some point. I mean, the draft of Article 27 that was when they were preparing for the Rome Statute triggered. I mean, this case. I think that many of if we go back, probably many of judges, prosecutors around the EU or around the world, probably they were trained with the new international levels that was going to be the Rome Statute. So, I mean, I think that it was a precedent before before we have some action of the ICC. And here I have it in this. I copied it out. It says at first, and also I think it was in the sentence in paragraph 61. It says, first, such person enjoys no criminal immunity under international law in their own countries and may thus be tried by those countries, courts in accordance with the relevant rules of domestic law. So I think in this case, what they saying is that if a person commits a human right violation, even though he has some kind of immunity related to the work he's addressing his country, like a minister, in a ministry or of a member of the parliament. According to this, they say that I remind me what this reminds me is Rajput formula that was applied in the Nuremberg case trial. It said even though I mean the crimes that were committed by the Nazis were not established in a statute, but it's the right of the human beings. It's beyond a statute, the right to life, the right to due process, and everything. I think also here in some way they apply that also that formula, the Rajput formula, when they say that according to during the investigations I think it was in paragraph 61, it says the according immunities. First, the immunity doesn't represent a bar to criminal prosecution in certain circumstances. Certain circumstances is according to international crimes, and the other one is that such persons enjoy no criminal immunity under international law. So here is the Rajput formula, and also probably they are invoking the Charter of Nuremberg and all the international treaties after that. Also because they say that under international law, they could also be tried in their own countries. And also I recall the trial against, in the country right now here in Peru, it was against his former president, Alberto Fujimori, for international crimes. Again, there were two cases here that they started back in the 90s, 91, 92, where it was La Cantuta and Barrios Altos. There was like a paramilitary group from the government that they did in those years extremely mass execution no one was tried, and they decided these people are terrorists, and they wipe them all. And these cases were trial in the Inter-American Court of Human Rights, and they said, okay, here was no fair trial, and the president under joint criminal enterprise was aware of these crimes. He needs to be tried. And in 2007, he was extradited from Chile to Peru, so he can be tried against crimes against humanity. They go into international crimes, and he was tried. He's now doing jail time because of these types of crimes. So I think when, and also what Professor Sripatri has explained us, and also Professor Frimpong, we need to relate it to Article 27 and Article 98. This is a question I bring here. So we can use the crimes that are, I think there are in Article, in the first, they're considering the first articles. A moment. In Articles 8, what are considered from Articles 6, 7, and 8.
Article 5 to 9 to 8.
Yes, correct. Yes. Yes. From 5, yes, forward the crimes. Yes, correct, Professor Milton. Yes. Yeah. If they box in the if the perpetrator box with all the investigations, I mean, Article 27 can be applied very easily. And I don't know, the prosecutor could use Belgium versus Congo, the articulation over there. So, I mean, if I'm the prosecutor, I will use this information. Okay, we have a case here. All the case law that in that case, Belgium versus Congo was used. So this former Minister of Foreign Affairs could be tried against these crimes in Belgium. I mean, it's such a way, as Dr. Ditaba told us, 98 for the due process, but you are like in a limbo, because you have 27, 98, but if you are the prosecutor office, I mean, you can use all the case law or all the information used that was used in Belgium versus Congo, so you can try someone who is trying to challenge the due process with immunity, even though he had committed international crimes. So, what do you think about that? We have, yes.
Close. I would want,
yes.
Now that you mentioned your arguments have tended to revolve around. I would want you to establish a nexus between customary international law provision regarding immunity, because that's a very critical point of discourse, and even at the time of writing. How do we bring in the customary international provisions of immunity relating to states and acts of state? And secondly, you remember, these immunities were granted on the basis that the acts of the sovereign or representative of the sovereign in a given state were actually constituted to be acts of the state. So the question, how would actually this come in, where it would be argued, for instance, that it would not have been contemplated that genocide would be an act of state, because the state would not commit those crimes, Article 5 crimes. So I would want, if you're able to establish nexus, because I think among us, we have not touched on the issue of customary international law with respect to immunity. And also the jus cogens, and bringing the jus cogens aspect of it. And you did touch very tersely the issue of the Vienna Convention, the treaty, that particular aspect that deals with the doctrine which deals with effectiveness of interpretation of the treaties. I think these are very critical aspects that would help us unveil the mystery of how Article 98 came about in the light of very mandatory coaching or drafting of Article 27. Because in a way, it looked like Article 98 would be rendered redundant or just inoperable altogether, or meaningless for that matter, self-defeatist, where a particular provision is very, very mandatory, like Dr. Vitava put it, Dr. Ranson had made it very clear when he was making that point. It's actually clear that the action-oriented version of Article 27, even through drafting, was intended to make with the word shall mandatory. But anyway, in a nutshell, I'm just requesting, since you have touched on that area, can you establish a nexus with what you touch with customary international law? And I'm sure Dr. Sripati will come in very handy in that area as well. In terms customary international provisions on and how it was reconciled within the statute. Secondly, the jus cogens, and you could also touch on probably the doctrine of giving the interpretation of treaties, effectiveness of treaty interpretation. So that when positively read and construed, we should be able to come up with a position that would be incontrovertible. Thank you, Doc.
Thank you.
That's open to any of our panel, any other, surely, any other person who might want to come in. Most welcome. Yes, proceed. Okay. Anybody else to proceed? Whoever feels can.
I think Professor Sripati I think he's mute. Professor, you are?
Oh, okay. Okay, he's now okay.
Yes, I think he was.
Professor Sripati?
Yes.
Okay, good. Sorry for that.
Thank you. Speaking of the concept of jus cogens national law, the meaning of which is peremptory norm of general international law. That is the meaning of jus cogens. So these norms are of the highest cadre in international law, and no state can afford to violate jus cogens. Now, the 7 principles under Article 2 of the United Nations Charter have been given the status of jus cogens. So that is why states cannot afford to violate any of the 7 principles under Article 2 of the United Nations Charter. Similarly, all the international labor conventions under the International Labour Organization have been put together, and they are known as the International Labour Code. So the other international instrument that has the status of jus cogens is the ILC, International Labour Code. Now, the question is whether Article 27 of the ICC has been given the status of jus cogens. Now, it is somewhat questionable because what I feel is the states may not have thought of providing the status of jus cogens to Article 27, because at the time of the negotiations in 1998, states felt that Article 27 being mandatory shall be followed by states. They did not expect that states would go back in keeping their obligations under the statute of the ICC. If they had thought of giving Article 27 the state jus cogens, then probably these problems that the ICC is facing today would not have come. So That is my submission as far as jus cogens is concerned.
Well elaborate.
Thank you, Professor, for your participation. Anyone else wants to address? Professor Litaba? Yes, I have you here. Yes, because it appears you as the first frame, so I think you want to participate. I mean, this. I think Zoom reads the minds. And you move. Okay.
You will recall that the OAU also sought to invoke Article 98 when it was actually the African Union, right? Sought to invoke Article 98 in defense of its position that there was sovereignty for its leaders when, as a bloc, they attempted to approach the issue of Article 27 and 98. Anybody wants something to say about this? Really? I feel that's an interesting approach. A bloc, you'll recognize that in retrospect, the African states also approached the Rome Statute approval as a bloc. There were over 50 states, actually. They were the majority of, the like-minded, when you see the like-minded kind of groups. So I don't know whether we have anyone else who would want to say something about the OAU's approach to Article 98. Back to you, Doc.
Okay. Well, from my point of view, Article 98 was, in some point, that's what I think. When they were drafting the Rome Statute under Article 27, and they began to build all the Rome Statute, I think at some point they tried, because there were also the commission of every country who was contributing with their specialists in the summits of the Rome Statute. Probably they will get to a point that okay, we have the immunity, but we need, as Professor Litaba told us, we need to at some point. I mean, if what happens if we mess it up with an international, I don't know, complaint related to a case. So I think it was, like the scapegoat. I mean, it was Article 98. It was, it was like more like an scapegoat. It was more like a backdoor in case in some point the prosecutor, I don't know, mess it up with something, so they can evoke Article 98, so they can be dismissed from the trial. Also, I guess probably at this point, maybe some group of the drafter were thinking, okay, what happened if one state is like a police state, and all these I don't know, complaints, investigations related to someone are made. Probably he's innocent, and they are trying, to use it for, I don't know, political prosecutors for their political ideas. Someone who is against a regime, and they will use all this. I mean, probably they try to put this Article 98. So if they're, I don't know. I mean, we are humans. I mean, they try to protect someone that probably will be in some country prosecutor because he's against the regime, and probably they will, use some information against him, so he can be convicted for international crime. So I think more than Article 98 is for trying to avoid political prosecutions against their political ideas to someone. So I mean, that's like a check and balance. We have Article 27, nonetheless, if you think that you have been in your country being investigated or and they are trying to prosecute in the ICC because of your political ideas, you have Article 98. So, but you need to challenge Article 98. You need to prove that under the situation of your immunity related to the government participation, probably this person was from the other party against the government. I don't know. I'm just speculating, and they try, and he wants to be tried for crimes that he didn't commit, but they produce some evidence that says something else. So I think it's probably something like that. I'm thinking more like Machiavelli, because in some countries, for example, here in Latin America, is the government who has the executive, who wants the elections. They are inviting for Secretary of Defense, Secretary of something, persons from the other group that are against them. So I think Article 98 was in somehow thought for those who are working in a country in diplomatic service, in some kind of high levels, but they are against the government who is in administration at that moment. So that's what I think probably when they draft the Rome Statute, they decided to one for due process, as Professor Ditava told, and the other one is, okay, let's put us all in the worst kind of situation, and that I don't know, here in 30, 40 years from the draft of the Rome Statute, the world is another kind of world where there is, a new world order. And, George Orwell's 1984 police state countries, and we need to somehow give, a backdoor for someone that is against a regime and he wants to be tried against crimes that he never committed, but they are reproducing evidence against him. So those are my thoughts about that. Thank you.
Yes, Dr. Ransame, it seems you have something coming up. You just made a very powerful. I recall last time about your space. Your space. That was very impressive. I keep thinking about that. Prosecutors. It's been a prosecutor for many, many years. Yes.
Yes. Well, I think I said enough about what could have been the purpose of having Article 98. Yeah. I think the drafters appreciated that there might be circumstances in the future that will really render the mandatory nature of Section 27, subsection Article 27, paragraph 2, unfair. To say, these circumstances requires that this person should have been given an opportunity to challenge the possible loss of immunity. So to guard against that, let's have Section 98. It may well be that there were acts of justification for what happened. Give me an opportunity to address you and say, I don't think it's necessary to grab my immunity away from me, because what led to my actions are as follows. So I think it was just an appreciation to say, you don't know what the future holds. There might just be circumstances that requires that a person should be given an opportunity to argue whether immunity should be taken away or not. That's why they decided to include 98 to a little bit dilute Article 27, subsection 2. That's my view on.
Oh yes, That is quite commendable. I would want to reinforce on that.
Yes.
Answer. Oh, sorry. I can see Dr. Sripathi is still online. Yes, I would like to reinforce on the position that has been advanced by. You did indicate, but the position really
Voted
is
వస్తుంది కదా అది.
because if we look at the drafting notes, the history of drafting, how they came up with this particular provision, Article 98, you will see at some point they were saying, let's wait and hear what, it's like they were waiting to get to know what complementarity group would say. There was the issue of complementarity coming up. So there was a waiting time to see what would emanate from the group that was dealing with the principle of complementarity, where actually that brings in the issue of what would be the position where the whole thing is taken back, because now you see primarily it is the domestic state that has jurisdiction to attend to these matters, not until such a time they are not able to, and unwilling. So you are very right indeed. When we look at the footnotes of some of these groups, you'll come across something like, let's get to hear what the group will say on complementarity. So just to use Professor Dr. Sripathi's word, enigma, like saying the US is quite an enigma. I think there was so much enigma approach to this drafting. Very interesting. Thank you very much, Dr. Bansana. You brought in a very critical point. But I would still want us to hear also something about the customary international law. Maybe Dr. Sripathi would say something about it in relation to this particular enigmatic provision. Yeah, so we know, as I said, this is a provision, Article 98, that the African Union purported to try to rely on it. But it's a very elusive provision, as you can see. No one knows entirely what was the purpose. But when you look at it again, it would look like it is self-defeatist. Like we have the Judge Kroll, who happened to be at the ICC, was leading the German team to the drafting party. I mean, that group that went, his party that went to the drafting session of the ICC, the Rome conference. He said, actually, there's no way Article 25 would not be, would be rendered unoperational, in the sense that without it, if we were to proceed by way of 98, we would just be rendering the whole statute inoperable. You see, it would be defeatist. So there is something. So I would request Professor Dr. Sripathi. Thank you very much, Dr. Ransane, for that very brilliant point. There's the issue of the customary international law here on immunity as a whole. Then there is the issue that I brought about, which Dr. Marotta mentioned, about the interpretation, the effectiveness of interpretation of a treaty. That's a doctrine. And we have the customary international law, which has a whole body. And I know Dr. Sripathi has been teaching this for over 30 years, the issue of customary international law in relation to this particular aspect here. You might also want to talk about the issue of the gravity that comes in when the United Nations Security Council invokes, Chapter 7 of the UN Charter. Whether that has anything, it changes the scenario in respect of Article 98. Over to you, Professor Dr. Sripathi.
CC is because of Article 27. Because US is apprehensive of the fact that the ICC may proceed against their military personnel and other official persons who hold high ranks in the US administration. Now, coming to customary international law, as far as state immunity is concerned, when we speak of principles of customary international law. These principles of customary international law are principles that have evolved from the state practice of the states, whether they come from a particular region or whether they come from all parts of the world. But certain customs that are followed by the states. Now, for a custom to be recognized as an international custom and to evolve as an international customary principle, there are certain conditions that need to be fulfilled by the custom that is being followed by the states. The first principle is the custom should have been followed for a long duration by the states, in the sense when any dispute is referred to a state, the dispute has to be solved by the application of the custom. So the custom should have been followed for a long duration of time. That is the first condition. The second is the custom should have been followed consistently. Every time a dispute is referred, the custom must be applied. Then, third condition is the custom must be uniform. Custom must be uniform. And then, next is there should be generality of practice. It is not necessary that all the states in the world should follow a custom. Even if a few states follow a custom, it fulfills the condition, that is of generality of practice. Then comes the last but most important condition, that is opinio juris et necessitatis. That is, the custom must be required by international law. Even if a custom fulfills the above four conditions, it is inevitable that the fifth condition also must be fulfilled. Only when international law requires the custom, it shall accept the custom, and then the custom shall qualify as an international custom. And with constant usage of these international customs, it evolves into an international customary principle. So state immunity has been practiced by states in the past, and it has been a custom in the whole of the international community of states following the principle of state immunity. And because of this constant and frequent use of this customary principle, it has evolved into an international customary principle. So today it is recognized as an important principle. So when a principle is recognized as an international customary principle, it becomes obligatory on the part of the states to follow the principle. Apart from that, we also have this Article 27 under the statute. So there is a kind of a double obligation, an obligation under the statute and an obligation under international custom. So states must follow. If not under Article 27, they should follow the internationally customary principle. This is my submission.
Thank you very much, Prof. I believe you agree with me that was very brilliant. It's very, very concise. And I think we've had a very expert panel. You've listened to Dr. Ransane bring out his points really amazingly, very clear as well. I'm very impressed by everything that went on. And I think you also know with Dr. Marotta will always give very practical examples that he has that always remains vivid in our minds, even when we close the panel. Our colleagues have been out because of, some have gone out of air because of the battery and other reasons. And I want to thank you very much for those who have been with us as experts. And thank you, our viewers, millions of you are watching on this platform right now, live on YouTube and other streaming platforms. You have seen for yourself that we are very, very competent persons who have everything at the fingertips. Thank you very much, Dr. Rampan, for taking your time out of this schedule. You have actually portrayed the government of South Africa as having very competent intellectuals who are able to reason out points at that level. And as usual, we thank you, Dr. Sripati. I'm very sure your former students are very proud of you. Who produced thousands of those lawyers over here. It speaks for itself. Whoever listens to him, you can see what he has brought out on customary just at the fingertips. And thank you, Dr. Marota, for all your wide experience with which you're using to guide and focus. Thank you very much for all those viewers, wherever you are. I think we come to an end of this session. And with my colleagues, panelists, we say bye-bye to all of you there. And
Thank you. Bye.
Thank you.
Thank you.
See you all next week.
See you next week.